G'day, everybody. I'm Leanne Minshall, the Strategy Director at the Australia Institute, and I'd like to welcome everyone to our webinar today discussing the first day of oral pleadings in the ICJ case looking at climate change obligations. To officially begin, I'd like to acknowledge that I'm sitting on the side of Kunani, Mount Wellington, which overlooks Nipaluna, Hobart, on the unceded territory of the Muwinina people. And this land always was and always will be Aboriginal land. Days and times vary for our webinars. We have a whole series of them, so please head over to our website and have a look at other webinars that we've got coming up. And also just a few tips before we begin to help us run things smoothly. If you hover over the bottom of the screen, you should be able to see a Q&A function where you can ask questions of our panellists, and you can also upvote questions if you're particularly interested in them. This discussion is being recorded and we will post it on our website, so you can look back at the discussion then. So the International Court of Justice has started last night our time to hear a landmark case on the obligations of nation states to climate change, its effects, and their responsibility for that. We're joined by two experts in the field. I'd like to really thank them for coming online today. It's about 1 a.m. in the Netherlands where they are. Both of our guests have been at The Hague today to watch the proceedings unfold. We've got Shiva Gounden, head of the Pacific, Greenpeace Australia Pacific. He leads the Pacific campaigns at Greenpeace Australia. He's an accomplished advocate for sustainability and climate justice with a focus on empowering communities in the Pacific region. And I'd love to welcome Shiva this morning, or very early this morning, your time. We're also really lucky to be joined by Katrina, is it Bullock? Yes, Katrina Bullock, who was awarded Rising Star in her legal profession, I think in 2020, worked at a top-tier law firm before being headhunted by Greenpeace Australia Pacific to serve as their general counsel. So thanks both of you for coming on today. Thanks especially for staying up so late. I can't imagine how tired you would be after the drama of today's proceedings. And Shiva, I'm going to start with you and just ask you to let people know how we got here. Where did this case start? Who was involved, and how did we get to where we are today?
Yandra Vinaka, everyone. I can say Yandra because I think it's morning in both sides of the world. And thank you, Leanne, for calling me an expert. I'm far from it. I'm sure Kat is, but I'm not. Yeah, I can give you a little bit of a story of a journey of this campaign itself. It's a beautiful story. I know usually people start off with 2019 when this came into fruition in a strong way, but it actually started in around 2009. I think it was when Palau wanted an advisory opinion on climate change, and at that time our Pacific leaders also didn't really support that. And then it took quite a few years after that, in 2019, when 27 law students in a classroom, well, across many classrooms, some online, some physically, who decided that if the leaders can't do it across the world, that they want to take this fight themselves of taking the biggest problem of climate change to the world's highest court, the International Court of Justice, especially to seek an advisory opinion on how their human rights can be protected from climate impacts, but not just theirs, but the future generations as well. So the story began beautifully in the Pacific Islands. And then they mobilized, I guess, the Pacific leaders with partners, civil society partners across the Pacific. And then all of a sudden, it became a global movement where it wasn't just the civil society in the Pacific, but civil society across the world. And then multiple governments came in. There was a steering committee that was created. And then last year, March, was when a pivotal moment happened at the UNGA, the United Nations General Assembly, when this resolution was passed through without a vote being needed, which is the first time in the history, where 132 countries co-sponsored that resolution. And then the journey to the International Court of Justice began from there in terms of the legal proceedings. And then it has multiple steps. You have two rounds of submissions where states make a submission around their case of why this needs to be part of there needs to be an advisory opinion that comes out of it. And then there will be states who will counter that as well. But that's just the legal components. There's so much of activism, so much of campaigning that has culminated to this process, to this outcome in the end. And now finally, after multiple years, people from across the world, from all cultures, all communities, from all ages, it is now at the footsteps of the International Court of Justice. Actually, it's gone inside the courtroom now, which was a very pivotal and very emotional moment, actually, for a lot of people who've been fighting this, especially from Pacific Island communities as well, because a seed that was planted then became something which bloomed into a very winter Netherlands with no leaves on the trees here. But it was you could see how much the emotion, how much this meant for the Pacific people. There was so much emotions outside the courtroom, but inside the courtroom as well, with powerful statements made by Vanuatu initially. So Vanuatu, all states get 30 minutes, but the interesting thing about this one was Vanuatu started with MSG, the Melanesian Spearhead Group, which includes Fiji, Solomon Islands, the liberation part of Kanaki. You've got Vanuatu as well themselves, and Papua New Guinea. And their statement was very different to what a legal statement would look like, because it wasn't just reading out statutes. It wasn't reading out legal policy elements only. It was making it very human and very realistic of what our people face in the Pacific. And that's why it was so emotional, because some of those statements, you had community members as part of their oral presentations, etc., which is also quite unheard of in the ICJ when it comes to these things. So extremely emotional moment, extremely powerful moment, a true testament of when the world comes together on what can happen. And now it's up to the court to come up with a judgment or a advisory opinion that actually listens to the frontline communities that face the climate crisis. I might just stop there, but a huge amount of credit to the Pacific Island students fighting climate change, the 27 law students who took this and who mobilized and unified the whole world to ensure that our voices as frontline communities are at the front and center of the biggest court in the world.
Yeah, I had the pleasure and privilege of meeting Vishal, one of the original students in New York during Climate Week. And I had only had a passing interest, to be honest, in this case up until that point. And I had a cup of coffee with him. And by the time I was 5 minutes into that conversation, I was a true believer and wanted to do everything I could. They're very inspiring. But for you, Shiva, were you inside the court as well, or just outside?
So I was outside today, but I will be in court in a few days' time. Actually, there's one more thing I wanted to add, is that a lot of these legal arguments that will be presented by many of the countries, especially global north, do not really involve a lot of community stories, or do not really involve community experiences. And that's what's going to be different with the Pacific governments, because they have included, and Kat and I can talk about this, that we were on this journey to try and gather stories and evidence from community members, and the journey just to get to those stories, it's a story in itself. And then and what came out of that, the heartbreak, the tragedies that the climate crisis have kind of put on people's doorsteps, has been humbling for us ourselves as people, practitioners of this kind of environment. So for me, as a Pacific Islander, extremely proud thing to see that the Pacific unified the whole globe. But Pacific leadership on climate crisis can never be understated. They've always been quite ambitious around this, but extremely humbling as well to see how we are not just alone in this fight. There's so many people who want to also ensure that there's a safer world for their future generations, and actually a beautiful moment of just young people who young people did this. Young people pushed the world to a very historic moment, and hoping that the outcome comes. It will take a few months after this, but it's something that our Pacific people can be proud of, and then also have that little hope of preserving whatever culture, language, land that they have available.
Thank you. Katrina, I might come to you if you can tell people. There'd be a lot of people here, I think, that don't understand why it's important that this case is being heard by the ICJ, and also the implications of an opinion that comes out from the court.
Absolutely. Thank you so much for having us, Leanne. Arriving at the court this morning, it was clear how much this advisory opinion means to people around the world. There were hundreds of protesters demonstrating outside the court, making it very clear that the world is watching and that what countries say and do over the next couple of weeks will not be forgotten. When the Minister for Climate, or actually the Special Envoy for Climate Change and the Environment in Vanuatu took to the stand, you could hear the chanting of protesters inside the court. And as Minister Ralph Regenvanu set the scene, he said that the outcome of these proceedings will reverberate across generations, determining the fate of nations like his own and the future of our planet. He noted that the stakes could not be higher and that the survival of his people and so many others is on the line. He trusted in the wisdom of the court to uphold the principles of international law. But over the day, we saw controversial testimony from so many nations, and there were gasps coming from the different chambers and the courtrooms. There was screenings around the city of the proceedings, and it really felt like this sort of pivotal moment where all eyes were on that court. I can speak a little bit more, if you like, to Australia's testimony, which was very much at odds with our Pacific and Caribbean nations today. But in terms of the broader implications of this advisory opinion, it could absolutely change the face of international climate law going forward. Advisory opinions in and of themselves may not be binding, but the law that they are interpreting often is. So we've got these incredible human rights laws that are scattered amongst treaties, things like the International Law of the Sea that says we must protect the oceans, things like the Convention on the Rights of the Child that say we must protect children. But because all of these treaties developed at a time where we didn't understand the scale and the impacts of climate change, they are silent on how to protect oceans from climate change. They are silent on how to protect children from climate change. Now, the International Court of Justice has a big job ahead. It is being asked to take all of these treaties, the entire corpus of international law, including customary international law, and to reinterpret it in light of the best available climate science, and to really come up with some concrete obligations for nations in terms of what they need to do to protect human rights from the impacts of climate change, and to opine on what the consequences are under international law if they breach those obligations.
Yes, thanks, Katrina. And it was interesting. Maybe we'll move on to Australia in a minute, but maybe if you could talk a little more about why the UN actually called for this in the first place. You know, why we already have so many treaties, as you've just outlined. We've got the UNFCCC process for to look at climate. We've got agreements from, you know, Paris on. Why the need for this opinion?
Oh, that's the question of the hour, isn't it?
Yeah.
So this opinion is needed because there are many countries at the moment that are interpreting international law in such a way that only the Paris Agreement and the United Nations Framework Convention on Climate Change applies. And they're arguing what's known as lex specialis, which is this international maxim we use to interpret international law that basically says if you've got really specific laws and norms, they should override general laws and norms. So because the Paris Agreement exists, some countries like Australia and Saudi Arabia are arguing that that and the UNFCCC framework are the principal tools that should be used in determining countries' climate obligations, and that we should ignore the entire body of customary international law that creates much higher obligations on nations to protect human rights. So because there is a lack of clarity around how to interpret these obligations, and we've got countries taking this rather self-serving and creative interpretation that the Paris Agreement wiped out this entire body of international law, it's really important that we get a strong progressive judgment from the highest court of the world showing countries how to interpret that law so that we can really drive change. Because, I mean, Shiva's just come off the back of the Conference of the Parties, the Global Annual Climate Conference in Baku. And anybody who attended that or who's been watching those proceedings will know how inadequate international global political negotiations have been in driving ambitious action on climate change. When the global stocktake happens soon, we will see how far away we are from the types of emission reductions we need to maintain a 1.5-degree world. And that has very, very real impacts for Pacific and Caribbean and other low-lying nations all around the world when it comes to their human rights, their right to life, their right to water, their right to culture, their right to self-determination, which was definitely a source of many submissions from Vanuatu and the Melanesian Spearhead group today. So it's incredibly, incredibly important in terms of clarifying the obligations of states.
I think it's interesting that you bring up the COP process. And Shiva, I see you've got your hand up. I'll come back to you in a minute. And for me, the reason why it needs to go to the ICJ is because the COP process and the UNFCCC is manifestly not meeting the requirements that the planet is crying out for. I mean, we're not winning the battle against climate change. So another avenue needs, we need help, basically. And for me, I think the ICJ also gives an opportunity for countries and the facts to be heard without the obligation for negotiators to be thinking about their national interests, because climate change is, it crosses boundaries. But for people who may not be around everything, I'm just going to go through a couple of the things that you said there. So all countries have to come up with plans about what they're going to do to reduce their emissions, and we get those updated every 5 years. And at the moment, on current projections, they're not going to be able to, the commitments from countries won't meet the action that is required. And so this court, hopefully, will provide more of a blueprint on what's actually required by the countries, rather than what's been negotiated in the midst or in the context of all of those negotiators thinking about their own nation state and their place. So, Shiva, I'll go back to you because you had your hand up.
Yeah, look, I might just add, Kat, I know, so GST, the global stocktake happened last year, actually. And I guess the NDCs, what you are talking about, Leanne, the nationally determined contributions, happens every 5 years. The problem with the Paris Agreement and the UNFCCC, although it is important to have that, but it doesn't mean that it should be the only thing that states look at when it, especially those who are climate vulnerable, because they are trying to tap into every single thing that is available for them to be able to do what the Paris Agreement and the UNFCCC hasn't done for so long. And few things, if you look at the GST or the global stocktake that came out last time, you had the false solutions were part of that stocktake. You had the carbon capture storage, you had carbon offsets, you had nuclear energy. All of those things were also involved in global stocktake language. So sometimes, and if you look at the COPs in the recent past, you had it in Egypt, you had it in Dubai, and you had it in Azerbaijan. Dubai and Azerbaijan are petrostates in a way. They openly promote fossil fuel industries, right? And if you look at the COP attendees also, it is full of fossil fuel lobbyists, and a lot of polluters are part of that process, which is why a lot of people actually have lost a little bit of trust in that process. And small island developing states like Vanuatu and others in the Pacific have decided that they want to also explore other opportunities or other avenues which will help them protect the communities and cultures. And that is something that they will strongly argue for, and what the developed countries will try and argue against. And I hope the court actually listens to those who actually have to protect things that they hold dear for so long that they have tried to, they didn't have that voice in the UNFCCC system. So just thought I'd add a little bit about some of the political dynamics around these things as well.
Thanks, Shiva. And I would add also that Australia is a petrostate. We're the second largest exporter of fossil fuels, and there are plenty of fossil fuel lobbyists wandering the halls of our parliament as well, and I think sometimes we forget that. Katrina, we were going to play a little bit from the proceedings themselves. I'm just going to ask my colleague Adam to pop into the chat box a link to where people can go and look for themselves to watch the pleadings that happened last night, our time. It was quite dry, so rather than play them, I'm going to leave it to people to go and watch for themselves if they'd like to. But I'm going to go back to Katrina to unpack a little bit around what Australia's pleadings consisted of.
Absolutely. So Australia did argue that the UNFCCC framework and the Paris Agreement are the primary sources of international obligations to address greenhouse gas emissions. And it submitted that government obligations under those treaties or other treaties or under international law should not extend beyond those frameworks. And that position is fundamentally flawed. It disregards decades of international human rights legal developments, and it directly contradicts the really powerful legal submissions we heard today of the Pacific, African, and Caribbean nations. So the UNFCCC and the Paris Agreement were undoubtedly created to protect people, not to shield states like Australia from accountability. And compliance with those treaties is necessary, but it is certainly not sufficient to safeguard human rights and the environment. Australia's proposed pathway would see fossil fuel emission reductions be completely reliant on voluntary obligations and political negotiations, which we've already mentioned just don't work. We are not on track to meet the temperature goal of the Paris Agreement and to limit global warming to a level where we would be able to safeguard human rights. Saudi Arabia made some very similar arguments today about lex specialis, but we saw countries like Vanuatu and Albania argue against that idea. And we saw one of the representatives from Albania describe Australia's submissions and this idea of lex specialis as taking a filleting knife to the holistic body of international law and driving that law back decades. So that's probably the first point that they argued. The second is around transboundary harm. So transboundary harm just refers to the harm that's caused if one jurisdiction or one nation state has activities that are carried out within their jurisdiction but cause harm to another nation state. And it's always been the case under international law that you cannot cause transboundary harm. But Australia, Saudi Arabia, and others today tried to argue this really novel and I would argue artificial distinction between traditional transboundary harm, so that the types we've seen in other cases where a river gets polluted, it flows downstream into another state, and therefore they're responsible for reparations in that state. And then they tried to draw this distinction between that and this new category known as climate change. Australia argued that the principle of prevention should not apply to harm that's caused by greenhouse gas emissions. And the reason Australia argued that is because the temporal approximation is quite different when it comes to climate change. It's not harm necessarily from an identifiable source spreading to another state, like we've seen in other international cases like pulp mills or the construction of a road. They argue that the harm caused is done by multiple states and that it's contributing to the bigger issue of climate change. So there's that causal nexus that isn't quite as clear and is a lot more complex when we're talking about climate change. Australia argued that that harm is widespread rather than localized. It accumulates really slowly over time. And the damage that it's causing can often be quite removed from the area it's occurring. So these sorts of arguments were very much at odds with our Pacific and Caribbean and African nations that spoke today. There was a lot of talk of the international principle of common but differentiated responsibilities and respective capabilities. That's the principle under the United Nations framework that acknowledges that different countries have a different level of capability to tackle climate change. And some countries didn't get the benefit of an industrial revolution that caused a lot of the climate pollution we're seeing today. So when we look at how to equitably tackle climate change, those countries should have a different share of the carbon budget. Unfortunately, under international law, there is no agreed methodology amongst nation states as to how to quantify what an equitable share of the carbon budget would be for each nation state. But we saw some amazing submissions. I think it was from South Africa today about countries having an obligation under international law to do due diligence in light of the most recent climate science and to come up with their own version of what an equitable portion of that carbon budget would be and to implement policies that would give effect to that. I might stop there, but feel free to pinpoint anything you'd like me to elaborate on.
Oh, well, I think it's just interesting because, of course, I mean, climate change is a new phenomenon. So we can't apply customary law or principles that we've relied on the past where there's been physical damage and there's the temporal proximity, and such as in pulp cases and rivers, to a new scientific reality that this damage is being caused on a planetary landscape. And so when I got up early this morning and watched it, I was actually, interested and a little bit inspired about some of the submissions that were looking at helping us as an international community to come to grips with how we do resolve this. We've got a problem that's very new, and Australia's sort of insistence of just relying on old ways of thinking about a new problem. I don't know how you felt as an Australian in the court, Katrina, but I felt I felt a little bit let down, actually, apart from feeling frustrated, because I think we're better than that. I think Australia can actually do a lot better. I think we're a lot smarter, and I think that we could actually use our position to work out what a global answer would look like, what a global solution would look like. Just for people online, we're going to go to questions and answers in a few minutes. But Shiv, you've got your hand up again, so please come in.
I think Australia also kind of pushed for causation must be addressed when it arises, and I want to kind of argue that a little bit. Giving an example of the Pacific, and you just have to look at the Marshall Islands when the nuclear testing was done and the non-communicable diseases that followed it. It didn't happen when the causation happened, as in it happened years and years after. Australia, during their submission, spoke a lot about small island developing state, that they support the climate impacts that happen, and they acknowledge that, and then what they have done with the Pacific to try and change their systems, energy systems, etc. on the one hand. And that was just because they want to keep their ties, that family tie with the Pacific. And on the other hand, they went against everything that the Pacific will be standing for at the International Court of Justice, which is to ensure that we go beyond the Paris Agreement and the UNFCCC and use these courts to ensure the protection of human rights for future generations. That's the main thing. The reparations part of it is another element, but it's not targeted just at Australia. It's all polluters in a way. So I felt, as a Pacific Islander and also someone who's kind of lived in Australia as well in my moments, that there was one side that they were trying to pull the Pacific governments to say that we love you, we are with you in this journey together. And on the other hand, they completely broke that trust. But you know what? It wasn't really surprising from what they have, from the communications and the conversations we've had with the Australian government, that they were going to take this line of attack. I just know that some of the Pacific governments thought it would be a little bit more stronger in terms of the support for the Pacific Islands.
Thank you.
And I think one of the most interesting speakers today was the last speaker from Barbados, who pointed out that while climate change is a relatively new phenomenon in terms of international climate law, a lot of the very wealthy developed nations who have signed on to these global climate treaties knew a lot more than they've let on about the impacts of climate change at the time. And the speaker from Barbados showed a number of official government documents from the United States of America, from the United Kingdom, from West Germany, showing that the governments had knowledge of climate change and its impacts at the time of signing these international agreements, which was absolutely mind-blowing. And at that point of the day, I was watching the proceedings from a screening room with a number of other CSOs, and there was just an absolute round of applause as that speaker took the podium.
Thanks. And CSOs, for everyone, is NGOs. It's just...
Thank you.
That's okay. I have got the link on me, but if people are interested, I think a Carbon Majors report written about 10 or so years ago by Rick Heady and others, and the Concerned Scientists Union, I think I've got that around the wrong way, the acronym, the UCS, started to look at the link, the causality, and actually, could prove that I think it was something like 62% of current emissions could be, the responsibility for that could be sheeted back to about 67 nation states and large companies. But anyway, we could have another whole webinar just on Rikiti's work. But if anyone's interested, just Google carbon majors and I'm sure it'll come up, Rikiti, HEEDE. So we've got a couple of questions concerning the influence of the ICJ and what do they actually have. But I've got one that's quite specific. So people will realise in Australia that we've got anti-protest laws are being ramped up across the country, and I think a lot of it is in response to the fact that governments recognise that Australia is going to get a lot less polite over the next 10 years as climate impacts really start to hurt. People are going to get more active, and I think the restriction of protesting reflects that. So the question from Anna Molan is, do you envisage this opinion, when delivered, could be used in the defence of climate activists facing criminal charges for civil disobedience?
Ooh, that's a great question. I don't expect the content matter of the advisory opinion to necessarily speak to the protection of civic space, just because the questions that have been posed by the United Nations General Assembly, that's sort of outside the scope of those questions. That being said, what's quite interesting is that COP31 will be held most likely in Australia in 2026. And it's a joint co-bid between Australia and the Pacific. Now, at that point, all eyes will be on Australia, and all eyes will be on our anti-protest laws that have been implemented around the country. We're now seeing jail of up to 2 years, fines of up to $22,000 just for blocking major roads or facilities in New South Wales. And the reality is we cannot win the fight against climate in Australia unless we have the ability to advocate for our planet and our people. So they are two fights that are absolutely complementary to one another and so important for the entire movement. But the ICJ work won't necessarily have an impact on that. I think COP31 will, though. I think that will be a real moment where our government needs to take stock, because there will be protests all around whichever cities the COP events are held in, and there'll be a lot of political pressure from other nations to ensure that right to advocacy exists at this global conference.
Yeah, I think it's an interesting question. And I think there's a lot of lawyers in Australia currently thinking about creative ways to use persuasive argument from opinions delivered by the ICJ. That's a beer conversation, Kat, we can have maybe sometime. There's also, this is really interesting, this one from Gillian. It's, will Australia's contribution be discussed only in terms of our domestic emissions, or will it take into account our total emissions, including exports?
So advisory opinions don't actually name any particular nation states. I think what we're likely to see in the ultimate judgment is a series of obligations that apply to all nations around the world. And what we might see is a subset of obligations for developed or developing countries. It's a big question mark whether they will use the types of categorization that exist in the Paris Agreement with Annex 1 and Annex 2 countries. But because of that idea of common but differentiated responsibility and respective capabilities, and the acknowledgement that different countries are in different positions to curb emissions and to adapt to climate change, we will see obligations and we will see subsets of those obligations, but we won't actually see individual countries be named. So I think some of the types of obligations we might see were posed in the submissions today. The Melanesian Spearhead Group pointed to the International Energy Agency's pathway to net zero by 2050. And of course, that pathway requires no new coal, oil, or gas. And so we might see something in the judgment noting that new coal, oil, and gas developments are inconsistent with the protection of human rights under international law. There's also been a lot of talk in the submissions of a nation's duty to regulate fossil fuel players within its jurisdiction. And I mean, the Australian Institute has some incredible research on this that shows that Australia's fossil fuel subsidies to fossil fuel producers and major users from all governments totaled something like $14.5 billion in the 2023 to 2024 financial year. So we still have an Australian government that is propping up the fossil fuel industry at a time when it's actually being asked to regulate the fossil fuel industry and to curb those emissions. So those are the sorts of obligations that we might see really borne out in a concrete way in this advisory opinion that could have some very real impacts on the Australian government.
Just thinking about that 14.5 billion in the subsidies, what can you remember? Actually, Shiv, you might know this because at the COP just passed, the Australian government, I think, committed $50 million to the Loss and Damage Fund to help small island states. But that's a lot less than 14.5 billion. I wonder if you have a comment on that.
On what was the 14.5 billion, Kat?
In subsidies that are given to the fossil fuel industry.
Yeah, look, I think the world grapples with where will we get climate finance to be able to put towards the mitigation, adaptation, and loss and damage needs of all the global South countries, especially, right? In this, the last COP was all about climate finance, and the world failed in trying to come up with a solution around where to get that climate finance from. And there is a solution, which is making polluters pay. Stopping subsidies is one of them, but also taxing fossil fuel industries because they are the ones who have created this climate mess. And that is one way of trying to get the climate finance that is needed. However, like I said, COPs are polluted and hijacked by a lot of fossil fuel lobbyists who are also sometimes in the pockets of politicians in these cases. And I'll just be completely blunt about that. And that's why the political ambition in these spaces are very low in terms of what is really required in terms of finance, etc. Your question around the exports part is an extremely important one. Actually, whoever asked that question, thank you for asking that question, because I think that's a lot of countries grappling with that. When I was speaking to the Australian Climate Change Minister before the COP around that, to push countries like Japan and South Korea who utilize the fossil fuel from Australia to change their policies and to reduce the export things, he was very cagey with his answer to say that Australia does not count Japanese cars locally as part of their own. I'm sorry, Japan doesn't count Japanese cars in Australia as part of their own emissions. We only count things domestically. And that's what the COP GST statement kind of promotes, to only look at your energy consumption, etc., locally and domestically. And that's where the issue is. And that's why this international law is important, because it's not for individual states, but rather what the whole world needs to do as one unified family in that sense. And that could have implications around exports. And it could have implications of what is it really needed to be below that 1.5 degrees so that communities can have that, like I said, opportunity and that hope to protect whatever they hold dear. So I can't presume that, but it could if it has a global kind of movement around it.
I think it's interesting. I don't know when this opinion is due to be released. I don't know how long this process goes for. So we might talk a bit about that. But I'm wondering, how would Australia host a COP if part of this judgment is saying that opening new coal and gas is inconsistent with a blueprint from the ICJ? That would be quite difficult, wouldn't it, for us to then host a COP? Would we not have to stop approving any new coal or gas to really legitimately hold that next international meeting?
Yeah, and I mean, even after the COVID was announced, there were a number of Pacific Island leaders who came out and said, look, if Australia is going to host this, they need to step up their game. As you're probably all aware, Australia's export of fossil fuels dwarfs its domestic emissions, and the exports are predominantly headed to countries like Japan, China, South Korea, and India. So those countries account for just over 43% of fossil fuel carbon dioxide emissions. And all of those countries are signatories to the Paris Agreement, under the UNFCCC framework. So this judgment can be quite powerful because it won't just apply to Australia, it will apply to all of those countries as well. And it will mean they need to curb emissions at the same time that we are. So it's problematic in a sense that it won't name and shame countries, but at the same time, it's a very collaborative approach. And there's no way that we ever would have got the United Nations General Assembly to vote in favour of getting these questions to the highest court in the world if they thought they were going to be named and shamed. So it's a very collaborative approach. It's an exciting opportunity, I think, for us to get some concrete obligations in relation to exports and domestic emissions, even if they're not specifying Australia as a nation. I think it's going to be very interesting. The bid is still on the table from Turkey, but in international circles, most people at this point do think that the Australia-Pacific bid is going to get up and it's likely to go ahead. There's every chance, because we've got a federal election between now and then, that we might actually have a very different government in power that also has very different policies around climate change too. So it could be a real sort of whip for the government's back. They could be facing international scrutiny at a time where they're not living up to their own commitments under international law. And it could be a very embarrassing moment for our government if they don't step up their game between now and then.
And when is the opinion likely to be delivered from the ICJ?
So traditionally, most advisory opinions take around 6 to 8 months to be rendered from the judges. You've got 15 judges of the court that work collaboratively on that. But this advisory opinion is completely unprecedented. We have never seen so many nation states make submissions. We have never seen so many nation states want to be part of the oral hearings. And that means that it could take the court a little bit longer. It is certainly a priority for the court based on their external communications. But approximately 6 to 8 months, depending on how controversial the submissions are over the next couple of weeks.
Can I just add, sorry, Leanne, to the previous question around the COP, Australia hosting the COP? I think there was a good comment in the that even without the hosting, Australia should stop opening new coal mines, new fossil fuel projects. Yes, there were Pacific states who were, and I remember being in that room in the Pacific Islands Forum when Marshall Islands government and Tuvalu and Vanuatu was just saying that if you keep opening this coal, new fossil fuel projects, we have to reconsider our COP support for Australia. I know that the Pacific countries are in support of Australia's COP bid with them because it provides a platform for the Pacific countries to be able to use their home advantage in terms of pushing for ambition. But they were very clear to the Australian government that they have to start thinking about stopping these new fossil fuel projects that they continuously continue every year. So I hope that Pacific leadership still stays strong in pushing the Australian government in ensuring that they are also ambitious in terms of the climate outcomes.
I've got a question from Michelle Smith that I'm going to ask you now. But while I'm asking you that, I also want you to think about if you've got anything that you'd like to share on next steps after the opinion comes out, both in terms of any further legal actions or state-based actions, but also what people who are interested in this area of law or just climate change generally might like to do. So I'll give you that one on notice. But the question from Michelle, and she obviously knows a lot about this by the way she's asked the question. It's a good one. Do you think we need a progressively increasing global levy on fossil fuels backed up by a carbon border adjustment mechanism with the revenue raised used to fund loss and damage? Michelle, I think that's a great idea.
Hell yes.
How do we get that?
Look, there's a movement across the world right now that's talking about climate damages tax. So tax that from fossil fuel industries or biggest polluters, to ensure that, so if they collect all of these taxes, it is far beyond the climate finance that is necessary currently in terms of addressing the climate damages and climate impact. So there is a whole movement and civil society is onto it as well. So thank you for raising that up, because I think that is one of the solutions that a few governments are pushing as well across the world. But it's whenever the talk of finance comes up, whenever the talk of tax comes up, especially Australia's previous history of the carbon tax, the narrative around the carbon tax wasn't taken well by the public. So the terms levy has thrown around, etc. But that is what the world currently needs, and it's not the people who should be bearing the costs, and that's why people get scared about tax, carbon tax, etc. Because it's always then put onto the people to pay for those tax, but it should be targeted directly at the fossil fuel industries and the polluters to raise that money and put it towards the climate finance that climate vulnerable nations need.
Yeah, the Australia Institute's done a lot of work over decades looking at what would be the effectiveness of levies put onto fossil fuel exports in particular. And our research has shown over and over again that it's actually quite a popular policy with the government. And if people are interested, again, they can find out more on that on our website. And I think might even have a petition going for it. Did you want to speak more to that, Katrina, or would you like to move on to our closing question around what people or nation states or anyone can do once the judgment is delivered?
Oh, that's a very exciting question. I'm going to jump straight there.
Right.
So we've already got lawyers around the world mobilizing to consider what a progressive judgment could mean for strategic climate litigation and for holding governments accountable. So I mentioned earlier that advisory opinions in and of themselves are not binding, but the laws they're interpreting are. And we're operating in a jurisdiction where our government has already ratified a number of these laws. So if it is misinterpreting them, then we have the opportunity to look at the international law, to apply this new reinterpreted model, and to hold our government accountable in that way. So I think we will see climate litigation around the world holding different nation states accountable based on whatever comes out of this judgment. I think what we'll also see is a new baseline expectation of country responsibilities at international conferences. So when we've got negotiators, particularly from small island developing states, walking into negotiations with big wealthy countries, we will have a new baseline expectation of what the obligations are to work from, which could completely change the conversation in those rooms and the zone of agreement, which is incredibly, incredibly exciting. So there's going to be a lot of ramifications. There's going to be a lot of upheaval. But I mean, that is the climate crisis. Every day, every part of a degree of global warming impacts the human rights of millions of people around the world. And so we're hoping to see a relatively quick rendering of an opinion by the International Court of Justice. And it is not done in isolation. You know, this advisory opinion is building on other progressive opinions from around the world. So we've just had hearings at the Inter-American Court of Human Rights, where they'll be rendering an advisory opinion. You might have seen the United Nations Tribunal on the Law of the Sea has rendered an advisory opinion on the impacts of climate change in that context, in the marine context. And it determined that carbon emissions can be considered pollution for the purposes of the Convention on the Law of the Sea, which is a really big deal because it means that countries have obligations under that treaty in order to curb those emissions and to stop that harm. So what we will see is this International Court of Justice advisory opinion that's building on the United Nations Convention on Law of the Sea opinion and the Inter-American Court of Rights Court of Human Rights advisory opinion. And we will see this body of international law that is built that can be used as a sword by lawyers around the world and by academics and by others to help drive greater ambition.
Shiv, what would you like to see? I'm sure there'll be some community responses as well after the opinion is delivered.
Yeah, look, firstly, I think a lot of our Pacific communities should celebrate this. Like I said, it's been years and years in the making, and just to see it in the court, which nobody gave the students a chance. You know, it's like I said, 27 students with no money, no resources, just a drive and heart and love and passion for their region and their communities, who decided to take this fight on. But they have a huge family supporting them right now, and they have a huge amount of love that's been shared. So the first thing I would say is for them to take this all in, because it's a momentous occasion. The second thing is we need all our leaders who are presenting. There was a beautiful question by Nicholas as well in terms of Indigenous people. How are they represented in this? And every Pacific country that will be presenting has used stories and evidence from Indigenous communities, and the communities will be also part of the oral presentation. So that is an important part that I hope our leaders, our Pacific leaders especially, use this next 2 weeks to make their statements as powerful as possible, so that the Global South voices around climate justice just rings throughout that whole courtroom. And then the third thing is the lawyers. Lawyers are people who have emotions, and I hope the judges who are sitting on this case right now truly understand that. Firstly, they made this whole process really difficult for communities. There was NGOs weren't allowed to make submissions to the court. You had to find different ways to ensure that the community voices were part of it. But now that it's there, I hope the judges can hear the noises that was outside today and has been made, and for the next 12, 13 days that will be made outside those courtrooms, to ensure that they stand on the right side of history. And then it's all up to the countries and their domestic policies, etc., to ensure that it's aligned with the justice that is required by those climate vulnerable nations like the Pacific Islands. So a huge process, huge amount of steps coming up, but exciting times for the world of litigation around climate justice, but also the Pacific leadership in terms of fighting for climate justice.
And do you think this will lead to inspire other young people or even old people like me to take action that maybe that
it has
we have
already? I'll tell you, it has already. Yeah, it has already. Just listening to people on the streets this week, just meeting young people from across the world. Like I said, a remote corner of the Pacific, Vanuatu, and then all of a sudden you hear Vanuatu everywhere in Netherlands and all around Europe, which is very rare. It has inspired many people across the world, and I'm sure it will continue to. I remember Vishal, who you said you met, said to me today. So Cynthia and Vishal was coming out of the courtroom because they were inside there with Vanuatu with tears in their eyes, and they said, we won't understand the gravity of everything that we've done just now. We will only understand that in a few years from now, because they have catalyzed a process that will just reverberate across the world, and especially for young people in Indigenous communities. So definitely it has inspired a lot of people, and it will continue inspiring a lot more.
Well, we only see tipping points in the rear view mirror. You know, we never see them when they're happening, and we certainly don't see them ahead of time, even though we like to pretend that we can create a tipping point. We actually judge them when we look back, and I think this will be a tipping point for climate action across the globe. And just thanks so much for staying up this late to beam back into Australia. Please pass on from everyone on the list our congratulations to the people over in the Netherlands doing such important work. And when do you guys come home? When do you get a rest?
Shiva, when are you having a rest? Are you like 2029?
I come back home. Well, I come back to the region in January. I come back home in February, and I don't get rest till about July next year. So let's see how it goes.
Okay, I'll take care of yourself. And Katrina, when are you heading back to Australia?
I head back on the 10th, and there'll be intense days, but it should also be noted that there's incredible solidarity on the ground here in The Hague. There are candlelight vigils. There is a people's court outside the International Court of Justice where impacted communities from around the world are invited to come and share their testimony. There are documentary screenings. This is an opportunity to meet up with people we've been working for around the world for years through screens and finally hug them and thank them for the incredible work they've been doing to drive this forward. You know, this is the story of a little grassroots campaign that began as a university assignment with 27 students and grew into the biggest global climate movement we've ever seen that will have reverberating impacts for many generations to come. So, I mean, if that's what a small group of stubborn optimists can do, imagine what we can all do together over the next couple of months and years.
We should have tried to get some footage of that inspiration rather than the Australia in the court. But well, if you need a good book to read on your way home, just letting everyone online know as well, it's the 30th anniversary for the Australia Institute this year. And we've produced a book called What's the Big Idea, with 32 essays on great ideas to change the world from some pretty amazing authors and people that we've hosted over the years, as well as people who work, researchers within the Institute. People can, I think, pre-order that through our website. It is a very good read. We'll leave it there. I'm sure there's something else I'm supposed to say to close the webinar off, but I can't remember what that is. So I'm just going to thank you both again. Thanks, everyone, for joining, and I'm sorry I didn't get to all your questions, but I'm sure that we're going to be hearing more about this, and check in to see what other webinars we've got coming up. And thanks again, and see you next time.
Vinago Vakalevu, everyone. Thank you.
Thank you so much, Leanne and team. Thanks for coming along, everyone.
Bye.
Thanks for watching. If you enjoy our videos, make sure to subscribe and hit the bell button to get notified when we publish a new one. See you next time.